afternoon, everybody. I'm just taking attendance, and then we'll get started in a minute or two here. Just notes as I'm doing this. Your midterm progress reports are available. Nothing should surprise you because I literally just take stuff off Blackboard. So if you do have any questions, feel free to contact me. But, you can see what I can see when I make the midterm progress reports. So, again, nothing should be a surprise to you. Just checking everybody off here. We few but mighty today, and I'm assuming other people will sign on as well. But I don't want to make y'all wait when you all are here on time, so I'm going to go ahead and get started. Let me just close anything that doesn't need to be running, just to help out. Alrighty. And I'm going to go ahead and share screen. Okay. Alrighty. So we have been talking about various types of civil assessments, and we were talking about, oh, sorry, helps if you can see my face. We were talking about personal injury assessments when we ended on Tuesday. So we had talked about what all the assessment entails and how do we actually look at things like malingering. People have a lot of motivation too, especially if there's a lot of money involved. So now we're going to talk about the timeline. And for personal injury cases, this is even more involved in some ways than some of the other types that we've looked at. So first you'll get a referral, and this is typically going to be from the attorney rather than the judge, as in the other cases. They'll give you a basic description of the case, and then you get that referring attorney's theories and supporting facts, and then you're going to want to talk to the opposing counsel and get their theories about what actually happened and their supporting facts. The examiner is going to provide information to the attorney about practice, what this will entail, how long it will take, expertise, so their training and what that means for how they can do things, and also their availability, whether or not they're sort of swamped with a bunch of these, and last but not least, their fees. If you're not hired directly by the court, this attorney is hiring you as sort of a contractor, an ad hoc basis. So you need to provide them with, this is the amount of money you're going to need to provide, right, in order to get my services. And I do have to say that psych in the law, forensic psychology, is one of the places where you can make pretty darn good money. So typically these folks will charge something on the order of $400 to $600 an hour. And now granted, I'm just realizing I heard that stat while I was in grad school, and it's been like 15 years. So that's probably more now. But typically you will be charging for like your time with the person or your time directly working on things. And the reason this is so high is to also account for like the time it takes you to write the report. Again, it depends on the attorney, the psychologist. They may incorporate that into their, it's actually per hour, and it's going to include when I'm writing, for example. There are cases where big firms just sort of keep psychologists on retainer, right? and then go to them whenever they have a case where their services are necessary. But if this is an individual case, then you would have a contract, the attorney-client provides informed consent, and then they would pay your initial fee, your initial retainer, to retain your services. So then you're going to do record reviews from both sides. So both sides you'll solicit records from, and then you'll do your first interview with the plaintiff. As I said, first, in this case, you're going to do more than one. So you're going to do a brief introductory interview of the plaintiff. You want to ask for collateral contact information, ask them to bring in their documents, and sort of just get their baseline information. Then you'll have them do in-office testing, like the MMPI would be done in your office. If you're going to administer something like the WACE, you have to literally be there with the person to do that. But then you're also probably going to give them take-home questions about their history, might be more general questionnaires, or just asking them like about the incident in more detail. And so then you will review all that. You'll review the scores you got from whatever you administered in office. Typically, you have the person either mail back. Now they may just scan it and use a secure server, or drop off what they did at home. And you go through all that, as well as any remaining records you hadn't gone through yet. And then you're going to do interview number 2. And this is your case substantive interview of the plaintiff. So this is your more involved interview. You'll also conduct collateral interviews, any witnesses or family members, fellow employees, things along those lines. And you will continue to do additional interviews with the plaintiff as necessary. So if as you're interviewing other people, you hear repeatedly from people, let's say this is a slip and fall case, right? And you hear from other people, well, that person, I watched them purposely kick the salt out of the way off the icy patch and step on it, right? Then you got to bring the person back in and be like, what gives, right? And sometimes they'll crack and sometimes they won't. So, you want to keep returning as more information becomes available, right? And again, those cases of malingering are actually pretty rare, especially for things to get this far into a trial. And then what you're going to do is you're going to review your data and your results. So everything that you've gotten, the records, the test results, the questionnaire results, everything from your interviews, and then you're going to start organizing them into your report. So you want to organize it beginning with the pre-allegation history, so pre-whatever incident is being alleged. And you want to look at what are the plaintiff's strengths and competencies. What were their pre-existing vulnerabilities? Again, that doesn't rule out that something new could have happened to them, but you have to make sure this is not something that already existed. And what were their pre-existing impairments in functioning? So if they, had had a stroke, but then they got a head injury, right? Like you have to try to parse that apart, which can be tricky. Trauma and distress. What was the plaintiff exposed to? How traumatic was it? How distressed were they? How distressed were they by whatever injury they may have sustained, if they sustained a physical injury, things along those lines. And then the sequelae, so substantial impairments in functioning that the plaintiff suffered. So how has their functioning changed as a result of this incident? And then ways in which the plaintiff has been resilient. So you might be able to say something like, this person has really struggled interpersonally, since this incident, but they are able to, still function in some aspects of their job that they can do independently, something along those lines. Then you want to look at proximate cause. So really focus in on, are there impairments in emotional functioning that would not have occurred had these events, these alleged events, not occurred, right? So let's say it's a traumatic event that they experienced in the workplace, right? Is it possible that this person would already have those symptoms, or did these show up after that traumatic event? And then impairments that would have occurred otherwise, right? So, again, let's go back to the example we were using Tuesday. Guy's driving along, the window falls off the truck in front of him, smashes his windshield, he's injured, he has PTSD, he can't drive anymore, right? So some of those are really clearly things that are caused by the accident, right? But if he had pre-existing depression, right, then you need to sort of parse out, like, yes, the PTSD is new, but he already had depression, that type of thing. But the accident didn't cause the depression, but maybe it worsened it. Then you want to talk about the prognosis. So what is the degree of future impairments this person will experience? Is this partial or complete impairment? Is it temporary, or is this going to be for the rest of the person's life? And then your conclusions will include your opinions and recommendations. And Jack always told us you should consult colleagues as you need on this, obviously keeping confidentiality, but you can ask in generalities about cases. Then you're going to do a consultation with the retaining client attorney and explain to them sort of what you found, what you're going to say in the report. If you're not going to say what they want you to say, they might be just like, thanks, you're done. Here's your money. Bye. Okay. But if it sounds like you're in line and that this would somehow support their client, they will have you write a written report. And as with every other report we've talked about this semester, you need to write this very carefully because this will be examined microscopically. It's not like other cases where like it might be. This will be examined microscopically because, again, there's often a lot of money on the line in these lawsuits, these personal injury lawsuits. You need to be prepared to defend every sentence in the report. One little thing wrong can destroy your credibility. One. You can call the whole lot into question, and in theory could sort of ruin your reputation, and then other people won't use you for those services. So how do you do this well? Less is better. You want to make everything as concise and clear as possible, because again, they're going to pick everything apart, and so you make less for them to pick and make sure it's all crystal clear. This is not the place to have typos. This is not the place to sort of hedge or not look stuff up. Again, you're going to be very careful. And this is one of the reasons why when people tell me, well, I'm going to be a clinician or I'm going to go into psych and the law, so I don't need to learn to write well, I just sort of chuckle and then try to set them right because you probably need to write better than someone who's publishing articles, because no one's going to take my article and dissect it piece by piece and make me defend it on a stand, right? But were I to write a report and give it to court, that could happen. So then discovery happens. The first step of discovery is a subpoena. In this case, you get it from the opposing attorney, since you've already been in communication with one attorney. And then you have to send everything you have over to the other attorney. And then step 2 is the deposition. So you are ordered to appear to be questioned by the other lawyers. Typically, your side's attorney is also there, so the attorney who hired you. And this is really similar to testimony in court. The lawyers will fire questions and you have to answer them. But there's no judge, there's no magistrate, there's no referee present. It's the lawyers, you, and a court stenographer to keep the record. That's it. So your side's attorney can object, but you still have to answer. So that's the weird thing. That's very different than court. You know, and then like, obviously the judge could rule on what could be admitted later. And if you were put on the stand, your attorney could object and you wouldn't have to answer, but it's really tough. So I've been deposed once in my life. I don't remember if I've told you all about this yet or not. So Jane Doe, who was a case that occurred, I think, before any of you got here. She was a Virginia Wesleyan student who was sexually assaulted during orientation. And she did everything right. She was the one who walked her friends home. They were in a group, and it was just she was the last one. And the rapist took advantage of that. And she went through all the Title IX procedures, and everything was done correctly until it got to the appeal, which was reviewed by one person who's no longer employed by the university. And he basically said, we're just going to let this guy withdraw voluntarily, since we don't want to damage his career. And in his letter he wrote to her, he essentially said, it wasn't the exact wording, but basically he said, we hope you get over this soon. And so because of, if the original event had happened and the original hearing had stood, none of this would have happened, but she sued. I mean, I don't blame her, right? And so this was a really long drawn out process. I want to say it took 3 or 4 years. And I was deposed because I was her academic advisor. No, I didn't know anything about this incident until 6 months later, because she didn't tell me until then. She didn't tell me until like January, February. But I think they were looking for background info, how she was doing classes, things like that. And that was really interesting because the assailant also was involved in the lawsuit, because she was also suing him. And so there were at that time, colleges, we weren't in a university yet, college's attorney, Rob Rowe's attorney, and then Jane Doe's attorney. So the other attorneys like looked at my CV and decided to try to use me as an expert witness as well as a fact witness, which you can't actually do. So they were asking me things about like articles I'd published, like one of them has the word sexualization in it. So they were like, oh my, and we're asking you, and I was like, this is this process, and this is what we were talking about. And, but I had to answer them, even though in court, I wouldn't be asked to answer those type of questions. So it was an interesting process. It was, to be perfectly honest, a terrifying process, because you don't want to perjure yourself. Right. And so it's just like, say everything right, say everything right, say everything right. And it's just so official and formal. And the college's attorney had like prepped me and had told me like, you don't want to be too overly enthusiastic. You don't want to gesture a lot. You all know how problematic that was for me, right? You don't want to get mad. And at one point, Rob Rowe's attorney asked me, don't you think that some women just decide that they didn't like having sex with a guy, so they said they were raped? It took everything in my will not to like jump across the table. And so I stopped and I thought for a minute, you know, I just don't have the type of relationship with my students where they would tell me things like that. It was just like the most honest thing I could say. But I held my hands like this the entire time, so I didn't gesture unnecessarily. And it was downtown, and I had to return something at MacArthur on the way home. And that's when MacArthur was really a mall. But I remember I was standing in line to return things, and it was just like the rush of adrenaline drained out of me, and I felt like I was going to pass out, and I was like sweating. It was very bizarre. So I hope none of you ever have to go through that, or if you do, you're much hardier than I am. But just wanted to tell you a little bit about what that process is like. That was a really unfortunate case. The lawyer she got had never done a sexual assault case before. He was sort of an ambulance chaser from Richmond, and he really mishandled a lot of her case, unfortunately. So it's a case they should have probably settled, but they didn't, and she ended up not getting anything. So you have to be really careful what you say in a deposition, as my story just told you all, because if you are called to testify, then you have to say the same thing. You can't like recant your story. I was not called to testify. I think I just wasn't that helpful to them because she hadn't told me about anything until 6 months later. So I was never called to be a part of the actual case. So out of, every 10 cases that go through this discovery process, only 1 or 2 of them are actually going to end up in court. So at some point a settlement will be reached or something along those lines. So if you are called to testify in court, which these cases, it's a little more likely you would be compared to some of the other types of cases we've talked about, because again, it's the attorney who's hiring you, right? If they think you will make their side look good, they're going to put you on the stand, right? So you want to be very realistic about your own credentials and expertise. You don't want to stretch. You don't want to overstate. You want to always be honest. If you don't know or you're not sure, say that. So when the college's attorney prepped me for deposition, he said, I don't know and I don't recall are perfectly logical answers, if that's true. And so you always hear people sort of like hedging in testimonies in front of Congress with that, but there were literally things I couldn't recall. Like they asked me what her grades were at midterm and like one of my classes. And I was like, I'm really sorry, I literally don't recall. Like I teach a lot of students, right? So it's better to say that. Also, if you don't understand the question, ask for clarification. It's better to ask. So if you don't understand what you're being asked, say, I don't understand your question. And then they have to rephrase it. You also don't want to volunteer anything, right? So you don't want to be, giving your testimony, answering questions, and then being like, oh, but yeah, they also had this trauma while they were 2 they mentioned, but no one asked you about that, right? You don't need to volunteer anything like that. Your role is to provide information that the lawyer that retains you wants you to provide in court. So this is where it gets a little trickier, right? So we've talked about psychologists always wanting to be objective and truthful, and you should certainly not perjure yourself. You should certainly not lie, but there are things you can focus on more because you are hired by this particular client. And again, this is because, remember, the attorney will have you explain things to them in the consultation. And if they don't like what you have to say, they probably won't even have you write up a written report, right? So you won't have gotten to this stage. So there are lots of spaces where the psychologist can step out and say, here's what I would actually say. Ethically, I can't lie. I can't say X about your client. I'm sorry. Oh, this isn't working because it's not on. That would be why. All right, so now we're going to talk about workers' comp evals. So these occur when you are hurt on the job. So let's say, let's come up with a ridiculous scenario. I was teaching en route. This is probably not that ridiculous. And a piece of the ceiling fell in, right, and hit me. And so not only did I have a physical injury, but I had PTSD as a result of, suffering a chunk of the roof, right? The reason I joke, like, maybe this could happen is because my first year at Wesleyan, maybe my first month at Wesleyan, a piece of my ceiling fell in the corner of my room, my office, and like no one cleaned it up for days. I had to contact Elaine Air to be like, who do I because she's so sweet and knows everyone that she just like hooked me up. They were there within the hour. But anyway, let's say it's this like dangerous chunk. It hits me, I'm hurt, and then I end up with PTSD. So what you do then is you file a claim for damages. And usually it would be like the scenario where there would be both physical and psychological damages. And this is not a judicial proceeding. There's an administrative judge who's appointed by the governor of your state or, in our case, Commonwealth. But if you aren't thrilled with the response, it can be appealed to higher levels of the workers' comp administration. So there is sort of an appellate process within. You would do the same kinds of assessments as a psychologist that you would do for personal injury cases. And the Workers' Comp Bureau doesn't have enough psychologists to do these evaluations. They'll usually contract with other psychologists. And also you might get roped in is the wrong word, but like brought in, there we go. Because if the worker's not happy with their evaluation provided by the Workers' Comp Bureau, they can get an independent evaluation. So you may be asked to give an independent evaluation. Depends on who hires you, who's the client, right? So again, typically you're going to be hired by the Workers' Comp Bureau. So just like when the court hires you, they are your client, not the person in front of you. So again, you want to make sure the person you're interviewing knows that. Okay, this is what this entails. The Workers' Comp Bureau is paying. They will get all this information from me. You usually don't get a lot of money for doing these. These are not like doing the big bucks personal injury cases. And honestly, there's not necessarily that much money for the worker either. So if the workers are compensated, the size of the award they receive is determined by the type and duration of the injury, and also their salary at the time of the injury. So it's essentially like how much work did you have to miss, and they kind of pay you for that. Workers can seek compensation for physical and psychological injuries suffered at work, the cost of whatever treatment is given, lost wages, which again is that related to the size of the award, and loss of future earning capacity. So let's say for some reason when I got hit by that chunk, I am now traumatized and can't go into roof, which is really problematic because that's where my office is, right? So either they have to move me to another office or I can no longer work. This is silly, right? I would get therapy and I'd be able to go into roof and I'd do exposure and I'd be good, right? But let's say extreme example, right? So they would have to figure out, okay, if she had worked X number of years as she would have throughout her career, how much would she have earned? Those are those lost wages, lost future earning capacity. And clinicians are often asked to render an opinion about the existence, cause, and implications of any mental disorder. So this is one where you do give an opinion about these things. Now, claims for mental disability arise in one of two ways. So the first is physical mental cases, where a physical injury can lead to a mental disorder and a psychological disability, right? So, it wasn't a workers' comp, but if we go back to the case where the guy was in the car accident because of the window, right? He had physical injuries from that accident, but then partially because of those injuries and partially because of the incident itself, he also had mental disability, PTSD. Then there's mental cases. And this is where an individual suffers a traumatic incident at work that leads to substantial psychological difficulties. So they experience a traumatic event and that leads to psychological issues. All right, so Hayden has put in the chat, when I worked at the law firm, we had a huge PI case where there was also a personal injury case, where there was also a workers' comp aspect attached to it because our client was a teenager who had been injured in a car accident. the huge monetary part of the case was coming from future earnings that were lost because she was only like 15 years old, so essentially all of her future earnings were lost. Yeah, oh my gosh. Yeah, they really can encompass a whole bunch of stuff. Yeah, and I mean, like, if the university had to pay me for, you know, let's say I'm going to work another 20, 25 years, right? And assuming I will get a raise every year, haha. Right? You've got to pay 25 years worth of a professor's salary and not get the work out of me, right? Hire someone else in my place. This can really add up pretty quickly for a company. This is why a lot of companies are very diligent about worker safety. And it's sad to say it's only partially because they care about the safety of the workers. A lot of it is sort of covering their butts in liability because of stuff like what Hayden just said, right? That can add up really quickly. In recent years, there's been a surge in the mental cases, and they're trying to figure out why that is. Well, might be due to the rise of, like, there are more women in the workforce now. You know, partially that's related to women experiencing more harassment and even assault in the workplace. But also women are just more often diagnosed with anxiety and depressive disorders, partially because they're more likely to seek treatment. So that could be a piece of it. There's also a shift in the job market from manufacturing and industrial jobs, which are being taken overseas or done by robots, right? To service-oriented jobs that yields increases in job-related interpersonal stressors, right? So more and more people are interacting, doing customer service, where they might have been in a job before that they could have easily had a physical injury in an industrial setting, right? And it could be motivated primarily by financial incentives. It's a little bit of a cynical view, but it's the truth. The other thing that's not mentioned here that I think is probably part of it too is, unfortunately, we have more mass shootings, right? You know, we had the horrific ones a couple weeks ago where 6 Asian women were killed along with 2 others. There was the one in Boulder more recently. If you are working there when that happens, right, you could have a mental, even if you yourself were not physically injured. Okay, so next we're going to talk about civil competence. So civil competence is something we've touched on when we were talking about competence to stand trial and NGRI, but this is sometimes just a separate thing that you are asked to make an evaluation about as a psychologist. So it focuses on whether the individual has the capacity to understand information that is relevant to decision-making in a given situation. So the capacity to understand information that is relevant to decision-making in a given situation, and the informed choice about what to do in that situation. Be able to make those informed choices. So this is a tangential issue, but this is kind of similar, to give it a framework to like what's happening with Britney Spears right now. I don't know if folks have watched the New York Times documentary about her, Framing Britney Spears, but she has essentially been declared incompetent to manage her own finances. Her father has been appointed the person who manages stuff for her, and there's some evidence to suggest he's not necessarily making decisions in her best interest, right? So she would have at some point in her past had to go through one of these type of evaluations in order for that to happen. So here are some questions that address civil competence. Is one competent to manage his or her financial affairs? Again, Britney Spears case. The ones that psychologists will be more often involved in are, can they make competent decisions about their medical treatment or psychiatric treatment? So typically, you know, again, if we're getting involved, it's often a case where this person clearly needs a higher level of care, like inpatient treatment, and they're refusing, right? So we kind of have to say they're incompetent to make this decision because of their symptoms, and so they will, be committed or sent to these care facilities against their will. Speaking of wills, so another thing that's questioned is whether you're competent to execute a will and decide how to distribute property. So unfortunately, with some of our older adults, what gets involved here is dementia, right? So if they have dementia due to Alzheimer's disease or strokes or Lewy body dementia or any other numbers, can they make competent decisions about who should get what in their will? And then can they make advanced decisions about medical treatment if they're terminally ill or seriously injured? So these are called advanced medical directives. Often when you go to the doctor or the hospital, they'll ask if you have one. These are also sometimes, these is a living will, and it basically says things like, I don't ever want to be on life support, or do everything you can to try to save me, right? So like a DNR would be part of this. That's a do not resuscitate, things along those lines. So people will make those documents while they're competent and have them on file so that if they are ever incapacitated, there's no question, right? They just go to that document that was made while the person was competent, and sometimes conscious, right, becomes the issue. So a competent individual will be able to understand basic information that's relevant to making this decision, apply that information to a specific situation in order to anticipate the consequences of those choices, use logical or rational thinking to evaluate the pros and cons of various strategies and decisions, and communicate their personal decision or choice. So when does this arise? When would a clinician be called in to do an evaluation for civil competence? Well, it usually, as I mentioned, arises when one refuses treatment that seems to be justified. So maybe you come in and you try to see if they can understand the information if you simplify it. So rather than using a whole bunch of clinical words, saying things like, we think it'd be really beneficial for, there's a big word. We think it would help you a lot to go and stay in this hospital for a week, 2 weeks, whatever. You would feel a lot better, that type of thing. If they still don't get it, you can administer a clinical assessment instrument. So like the MacArthur Competence Assessment Tool for Treatment Decisions, the MACPAT-TB, I guess. I really love their abbreviations. To determine whether the patient lacks the necessary ability to reach a competent decision. So we don't want to make these decisions lightly, right? We want to make sure that we're sort of checking that this person actually is incompetent so someone else can make this decision for them. Oh, there we go. I have it written out for y'all. That's more helpful. All right. And then clinicians can evaluate whether a person who's called a testator was competent to execute a will. So again, this is a separate type of thing, and psychologists, especially neuropsychologists, might get involved here because of, again, like the dementia component, which they have knowledge about. Such competent is a requirement for the will to be valid. If the will is not valid because the person was incompetent at the time it was created, then essentially the property reverts to whatever the laws are in that municipality. So evaluations include a determination of the purpose of the will and why it was written at that time, information about property holdings, insight into family dynamics, right? Really what you're doing in this case is you're making sure sort of a manipulative family member didn't take advantage of someone being in a weakened mental state to get like everything left to them. And then an assessment of the general consequences of the dispositions, so of the will itself. Alrighty, next type, employment discrimination and harassment. So in particular, we tend to look at sexual discrimination or harassment, but we can also look at racially based, ethnically based, age discrimination, or discrimination based on disability. Sorry, just kind of chuckling because in some cases, disability means being pregnant. So there are times when can you all still hear me? If so, go ahead and type in the chat that you can. My computer is doing something strange right now. I'm cutting out. Yeah, I think I'm having some internet problems. Okay, now I'm better. All right. My mouse doesn't work, but that's okay because this works. Thank you. Thank you all for saying, oh, and your sidebar is back too. So awesome. Yeah, I think I had a little internet hiccup. I've been having some problems. I had to sign on to one class with my phone the other day. So, all right, thanks again. All right, let me start this slide again, just in case people miss stuff. Okay, so what types of discrimination are we looking at? So primarily we think of like sexual or gender-based discrimination or harassment. It can also be based on ethnicity, race, age, disability status. So whether or not you have, you know, you're wheelchair bound, or maybe you're unable to pick up X amount of weight, that type of thing. So a big piece of this is Title VII of the Civil Rights Act. So we're much more familiar with Title IX in a educational setting. But Title VII basically does the same thing, only for a workplace setting. So the gist of what this says is you can't make an employment decision on the basis of sex, race, color, religion, or national origin. Another thing that comes into play here is the Equal Opportunities Act. And this established, I don't know what my computer's doing. Hopefully it's not overheating. I've had it on all day. All right, so the Equal Opportunities Act established the Equal Employment Opportunity Commission, which you may have heard of. Sometimes in ads, they'll say things like EEOC approved or whatever. So that is a really important piece of how these discrimination cases proceed. And then the Age Discrimination and Employment Act extends these types of protections to older adults. So you can't fire someone just because they're old. And then what we're looking at here are what are called protected classes of people. So we're looking at discrimination effects on a group, or what they call a class of people. And so psychologists will testify as experts about research finding. So for example, if someone is discriminated on the basis of race, then the psychologist would come in and they would be an expert in racial differences and racial inequities. And they would, you know, explain that as an expert witness. But we can also testify about the discrimination treatment of that individual, where the individual will say, I have been discriminated against, so I need to claim damages because of that. Sometimes it's a lost salary, right? They didn't get the salary they would have, were they male or white or able-bodied. And sometimes it is, you know, other damages, psychological damages, just like in the other cases we've just talked about. So psychologists, in this case, do individual evaluations, but they can also do expert testimony on the effects of discrimination. So they can be involved in both ways. Yeah, my mouse still isn't working, but hopefully
Cool, cool. Give me just a sec. Let me see if I can get my computer to recognize my mouse again so I can advance the slide. Not recognizing my keyboard either. Cool. All right. So here's what I'm going to do. I'm going to restart my computer. So I should be back in less than 5 minutes. If you don't mind, hang with me and I'll be back and hopefully everything will be functioning. So I'll be right back, y'all.